Hi everyone, this is Hamida. Welcome to Safavi Law Channel. Today's topic is insanity, that is Section 84 of Indian Penal Code of General Exceptions. So, what are that Section 84 of Indian Penal Code? We can also say about insanity or unsoundness of mind. Essential elements, when we discuss about the essential ingredients of that insanity, that is the first one, it is presence of mental disease or defect. So here insanity, it is nothing but what, some mental defect, means some kind of disease they are suffering. With that mental disease or the with that defect of that mental disability, if they committed any act, whether they will be punishable or not. So these are that essential element which has mentioned in the according to the section 84 of Indian Penal Code. That is the first one, it is the presence of the mental disease or the defect, means a person, in the sense the accused who is having the mental disease, suffering with the mental disease or that mental, any kind of mental defect. Next one, the inability to control their action as a result of that defect. In the sense, with that mental disease or the mental defect, they are unable to control that particular action. In the sense, that person doesn't, the accused doesn't know about what he's going to do that particular action, and he doesn't know whether that particular act is right or wrong, and he also doesn't know about that the particular act is against to the law or not. So another essential elements of the section 84, it is inability to differentiate right from the wrong as a result of that act. So he unable to differentiate it, whether that particular act is, whether whatever the act he is doing, whether it is right or wrong, whether it is against to the law or not, whether that particular means a person, whether the person having any menstruation primarily or not, means he doesn't know about anything else what he is going to do. That is which has been mentioned in the essential elements of that section 84 of IPC. Now we will discuss about the history of the insanity, that is the origin of the rules on the plea of the insanity. We know that insanity when we test about the history of that insanity, this legal insanity used in the 16th century only, means this particular term who used in the 1700 year. So first one, they decided that few test legal insanity, whether the person is having that insanity or not, whether that particular accused get that punishment or not, on the basis of three tests according to the various cases they have discussed. First one is that wild beast test. Wild beast test, it came from the first test evolved in the R versus Arnold case, which has happened in the year of 1724. So in this case, wild beast test, in the sense what, means a person who is suffering with the mental illness, and that person, whatever the act committed against to the law, and he doesn't know what he is doing. So these things which has mentioned in that particular case according to that particular related wild beast test. Next one, that next case, it is relating to the second test evolved in the case of Hatfield's case. This one happened in the year of 1800, that is insanity delusion test. Delusion, in the sense, we know that means the accused, means a person doesn't know what he is doing, the first thing, and the next thing, somebody, means few people are going to do against to him, somebody, means a few of the people, they are going to harm against to him. So in that particular delusion, if they committed any act, whether that particular act which is comes under the defense or not. So according to this particular case, according to this particular insanity delusion test, they decided the person is also having that delusion, and this delusion is also comes under the insanity, but this will be punishable or not in the Naughten cases that they have decided. So next one case, it is relating to that, the third test, it is relating to the Bowler's case test. In this case, they said about to the one of the tests, that is the right and wrong test. Right and wrong test, but not clearly discuss about the particular test, because of that particular accused know about that what he is doing, whether that particular act, whether it is right or not. This one not clearly described in this particular case, but in the next case it is relating to the McNaughton's rule case or McNaughton's case. They have clearly decided whether that person knows that action, whether it is right or wrong. So as per the few rules, they decided whether this particular act or this particular case, whether it comes under the insanity or that insanity comes under the general exception or not. So first we will go through that. What is that McNaughton's case? McNaughton's case, it is the McNaughton who was in the delusion, who thought that the prime minister who go against him, who tried to kill against him, so on that delusion he killed to the secretary of the prime minister. He believed that, he thought that the secretary only the prime minister. So that the case came into the House of Lords. The House of Lords, where with the various judges, they stated about that the delusion, one of the insanity, but it is not comes under the legal insanity. Then they decided, they framed the various rules. As per these rules, this section 84 also framed and they interpreted in the Indian Penal Code. Now we will discuss about the what are those rules and in which year this McNaughton rules came. This McNaughton rules came in the year of 1843, and that the first rule, it is relating to that if the person knew what he was doing or was only under a partial delusion, then he is punishable. Suppose a person knows about it what he is doing, and that particular who is in the delusion in the sense is also schizophrenia. In general term, in the psychology we use that term, it is the schizophrenia. In that particular, at that particular disease of suffering with the particular disease, committed any offense, of course this is comes under the insanity, but it is not considered as a legal insanity. So this one of the rule framed in the McNaughton's rule. Next one, there is an assumption that every man is prudent or sane and knows what he is doing and is responsible for the same. So here, according to that next rule of that McNaughton's rule, that is whenever the case came to the court, first we have to assume that the particular accused is a sane person. Might be that person is suffering with any insanity, but still while doing of the interrogation, we have to be assumed that the particular accused who is a sane only, not the insane person. Later on, after the various interrogation, then they decided that particular person is having the insanity or not. Later on only they will decide it. Then next one, in the McNaughton rule, another rule they framed it, that is to establish a defense based on the insanity. It must be ascertained at the time of perpetrating that act, the accused was in such a state of mind as was unable to know the nature of the act committed by him. So while doing of that act, means that the accused not in such a mind what that act he is doing, means he doesn't know about what he is doing. Suppose example, if some person is going to murder or some going to do some of the unlawful act, he doesn't know what he is doing. He doesn't know about the what is the meaning of that murder, what is murder, whether it is a right or not, whether that particular act what he is doing it is against the law or not, means he doesn't know about the particular total about that particular act. Next one of the rule about the McNaughton's rule, it is a person who has sufficient medical knowledge or is a medical man and is familiar with the disease of insanity cannot be asked to give his opinion, because it is for the jury to determine and decide upon the questions. So might be means the accused who is suffering with the medical insanity, might be the medical record they have given about that mind means that the capacity of the mind, means it's relating to the illness of that particular person, but still it is depends upon to the jury only. As per that questions relating to the jury, if accused can give a proper answer to that question, then that the person is not having the insanity. According to those questions what they frame, and that it will be happen only in the court, not by the medical record. So these all are the rules which has framed in the case of the McNaughton's rule. Okay, now, so as per that, we know about that few brief idea relating to the what is that medical and the medical insanity as well as the legal insanity. Even in the Naughten's rule, not given the priority to the medical insanity, only they have given the priority to the legal insanity. In the sense, what jury only have to ask the questions to the accused as per the answers, as per the relating to the whatever the answers given by the accused, then that jury can decide whether the person understand about the act or not. As per that only they can decide it, and then only will decide about that it goes to the general exception or not. So which has already framed in the case of the Naughten's rule various rules as per the various rules, and those rules only framed in the section 84 of Indian Penal Code, that is the insanity. Now we'll discuss about the differentiate about the what is the medical insanity and the legal insanity. We know that medical insanity means we have the various diseases. Some people are suffering. In recent scenario, many people are suffering with the medical insanity, whether in simple like people are suffering with the anxiety disorder, depression disorder, and attention hyper disorder. With that hyper disorder, many people are doing illegal acts. Then as per the medical record, as per the medical way, it is an insanity only, it is a disease only. But what about the legal insanity? Whether in the legal insanity, those people will be exempted if they committed any offense, if they committed any crime, those people will be exempted or not. So in the legal insanity, they will decide while doing of the act, that particular person having knowledge about the act or not. If the person is not having any knowledge about the act, then it is considered one of the exception. Another point of that which has discussed previously in the essential element, he doesn't know about that particular act, he doesn't know about that particular thing which is against to the law, he doesn't know whatever the act is doing whether it is right or wrong, then it is comes under the legal insanity. Along with that, lucid intervals, we can also say about that we have that in the medical insanity, lunacy, various diseases we can see in the medical record. Lunacy is also one kind of medical disease, medical defect, or the medical inability we can say about that. So here legal insanity, lucid intervals, suppose people are having some kind of disease, but in some situation in the lucid interval, in some period, they are aware of that, they have some knowledge about the act, means what he is doing, what is right and what is wrong, they can understand. In that period, in that lucid period, if they committed any unlawful act, if they committed any crime, then as per that they will give the punishment. Then at that time, if they committed any offense, they understand about the act, then it is not comes under the general exception. Legal insanity is also how it can be testified, in the sense, first thing they will see about the previous history while doing of the interrogation. They will check about the first one is the medical history, what that from the how many years the accused is suffering with that insanity. Later on, after that interrogation, they will decide about the after the commission of the crime, whether the accused absconded or not, or he sit and they means he only that the whatever the question they asked to the asked by the police or to the jury, he unable to give the answer, he unable to understand what he is doing, even though he are not absconded from the particular place where the offense happened, then we can decide that that particular person is suffering with that legal insanity. As per that, whether that the accused can be exempted or not, the judge will decide it, whether the accused having the criminal liability or not. According to those tests, they will decide. So these are the things which has mentioned differentiated whether it's a medical insanity and the legal insanity. In the sense, in the Indian Penal Code, according to the criminal liability, only they will prefer to the legal insanity, but they don't give the importance to the medical insanity. Because of that, we know that in the medical insanity might be a person is suffering with that anxiety or disorder or the depression disorder. They know about that what is right and what is wrong, they know about that what is law. Some people they know about that what is law, some people they know about that what is right and what is wrong, and sometimes they understand about that particular offense names also. But in that certain period with that high depression, something else, if they committed, then they will decide it, how in what situation they committed. Then that the medical insanity is not an important essential thing for the in the according to the section 84 of the Indian Penal Code, but only they will give the importance to the legal insanity. Okay, so moreover that, now we will go to the one of the case law. It is relating to that insanity. That is Bhikari versus State of Uttar Pradesh. Here, the accused was working in the field. A few months before the occurrence, he had threatened to kill all the family members of the deceased. Further, on the date of the event, though there were other people around, he carefully chose only the children of the deceased family. All this indicated that his acts were deliberate, premeditated, and not acts of an insane man. So here clearly we can understand about that. Here in particular case, the accused who already said about to kill to the family members of the deceased, and one day he chose to the only the children of the family member, and he killed and he absconded. In the sense, what he might be suffering with that some medical insanity, but legal insanity, when we see the person who absconded and who chose to the preferable person only. So here clearly said it is not comes under the exemption of the insanity, and that the accused punishable. So in the sense, medical insanities are not having not given a much priority. Yes, but it is also one of as a medical as a evidence we can use it, but they will prefer to the legal insanity only. I hope you can understand about the section 84. We'll discuss the various exceptions in the next classes. Thank you.